Good morning and welcome to the second of the RAS webinars for this summer, an introduction to the basics of GDPR. My name is Deborah Harding. I'm the Managing Director of the Market Research Society, and I will be the person presenting today. This is the first of two presentations on GDPR. The next one is the same time next week. But today I intend to cover 5 topics: an overview of the legislation itself, the data protection principles and definitions, and also the grounds for processing of data and use of client-supplied data. So those are the 5 topics that I'm going to cover this morning. Okay, so let's have an overview of the legislation itself. Data protection is all about ensuring people can trust you to use data fairly and responsibly. There's been an awful lot of discussion about data protection, what it is and what it's about. But if we kind of come back to this basic principle about fairness and responsibility, then that really sort of reminds us about what it is that GDPR and data protection is trying to do. If you collect information about individuals for any reason other than your own personal, family, or household purposes, you need to comply with GDPR. And so, as recruiters and as individuals involved in recruitment, clearly anything you do with recruitment for research purposes has to comply with data protection and GDPR. Now, I sort of will use the terms GDPR and data protection intermittently. But in terms of the actual legislative framework, the UK data protection regime is set out in the Data Protection Act 2018. But we have in parallel with that, we actually have something called the UK General Data Protection Regulation, UK GDPR. And that was introduced as a result of the UK leaving the EU. So this was part of the Brexit arrangements. And so, in effect, you've got sort of 2 parallel pieces of legislation which really are doing the same sorts of thing. The only reason why they had to introduce an extra piece of legislation was there were certain things that were enshrined in the EU GDPR which hadn't been brought across into the Data Protection Act 2018. And so the UK GDPR had to be introduced to enable that completeness. And the important thing, of course, is that the legislation has been recognised as being adequate, and that means that that in effect the UK legislation parallels that of the EU GDPR, so the 2 are the same. The UK GDPR takes a flexible, risk-based approach, which puts the onus on you as organisations and individuals that process personal data to think about and justify how and why you use data. That's really what the responsibility part of it, when we're talking about the responsible doing data protection responsibly, the responsibility is about justification, about the how and the why you use data. And the organisation that you're responsible to is the Information Commissioner's Office, the ICO, and they are the data protection regulator in the UK. So fairly and responsibly using data. So that's about fair and proper use of information about people. It is part of the fundamental right of privacy, is about building trust between people and organisations. And I do think it's important with GDPR that we also take a step back, because GDPR legislation is about our rights. It's about us as individuals, as citizens. And so what you would expect in terms of the protection of your data, the way your data is treated, and what you would expect in terms of being told what's going to happen with your data, being given an opportunity to opt out of something if you're not happy with it, but also to have control over the use of the data. You would expect that as a citizen. I certainly expect it in terms of the way that my data is dealt with. And so also you have to think the mirror of that when you're doing your business activities. What are you doing? How are you doing it? Are you offering the same degree of transparency and accountability in what you're doing with other people's data that you would expect of data that's collected and used about you? And it's that kind of treating people fairly and openly and recognizing their rights, recognizing the right to have control over their identity and their interactions which is core to really getting to grips with data protection, doing it in the right way. There is a really good reason why GDPR was introduced. It wasn't sort of done as something to make our lives really difficult in the last few years. There has actually been some kind of sort of privacy regime in the EU and the UK really since the 1970s and 80s. But as digitalization became more prevalent and there was more and more significant flows of data as part of trading and so on, it became part of international treaties that there would be common standards that would enable the free flow of data across borders. And that's really where the sort of early days of the regulation started and how we've got to the point where we are now, where obviously we're talking about millions and millions and millions of data flows every day. Having good practice in data protection is vital to ensure public trust in engagement with and support for innovative uses of data, both in the private and public sector. For research and data collection that you do as recruiters, it's all about the willingness of the public to talk to you and to talk to us. And if there isn't the trust and the faith in the research sector by the general public, then we might as well all go home. And so GDPR and data protection is a really, really important ingredient in creating that trusting relationship, as is the MRS Code of Conduct, which obviously looks much more at the ethical side and on what's happening in research practice. And also, for example, all the things that we've done the last 18 months or so with our COVID-19 data collection guidance that we produced. These are all part of a jigsaw puzzle of codes and regulations and legislation, which means that we are acting in the best interests of participants, doing good for research as well, but making sure that we protect participants and protect ourselves in the way that research is undertaken and data collection is undertaken. So that kind of sets the scene, I hope. Now, the important thing of any legislation is actually the definitions, because the definitions tell you what's in it, but it also tells you what's not in it. So really, really understanding those definitions is a core part of understanding any legislation. So let's start with the first one, where a very long description of personal data. So I'm going to read this through, but don't worry, I'm going to talk a little bit about what this actually means in a second. So personal data means any information relating to an identified or an identified natural person. And that is the data subject. The natural person is a data subject. So that's me and you, we're data subjects. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier or identifier, such as a name, an identification number, a location data, an order identifier to one or more factors specified to physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So pretty much everything and anything that applies to a person. And the GDPR applies to the processing of personal data that is wholly or partly by automated means, or the processing other than by automated means of personal data, which forms part of or is intended to form part of a filing system. So this is paper records, which are part of a filing system. And that can be from a Rolodex to an address book to whatever you might use, as long as it is part of a filing system. So let's step back a bit about what that actually means. So it's about personal data means information about a particular living individual. It is important to note that it's about living individuals. So once a person dies, they no longer have data protection rights. And that is also very important in terms of keeping records up to date for things like when people do die, so that you are actually doing that process, because that's kind of part of GDPR. But it relates to, it could be any living individual. So that's a participant, that's a client, that's an employee, partner, member, supporter, business contact, public official, or a member of the public. And it doesn't need to be private information either. I mean, even if information is part of the public knowledge or is about someone's professional life, it can still be personal data. So for example, my email address at MRS. That whilst that is corporate data, it is still also personal data for me, because there's nobody else that is deborah.harding@mrs.org.uk. So it is also thinking very expansively about data that and about whether data is personal data. If you could still identify someone from the details, or by combining it with other information, it will still count as personal data. So whilst you might have a sort of subset of information about somebody, you've stripped away some personal identifiers, if you still have identifiable information about that individual in another part of your database, for example, you still have to treat both parts of the data as identifiable data, because they together could still identify somebody. And so my general advice to you is assume that any information that you have about a living individual is going to be personal data. And that is true in terms of also things like photographs, recordings, audio recordings, as well as visual recordings, anything that could identify somebody. And whilst you might think, well, from how can you, got a member of the public talking on an audio recording, you can't see their face. How likely is it that they could be identified? Well, the issue is they could be identified by somebody. And so that information, their closest relatives and family or whatever. And at the end of the day, if somebody can identify them, then it is identifiable information. So, and if you, as I say, if you think about everything and anything you collect, always treat it as personal data, even if it's anonymous, that you think is anonymous data, treat it as personal data, and then you're on the right side of the line should it turn out that the information is personal data after all. And in terms of the actual what processing means, so the processing of data is in relation to personal data, means any operation or set of operations which is performed on personal data. And it's interesting when you sort of, and it's whether by automated means, it could be literally anything: collection, recording, organization, structuring, storage, alteration, retrieval, consultation, use, disclosure, dissemination, restriction, erasure, or destruction. If you do anything at all with personal data, it will count as processing. Even if you just kind of open a file and look at it, just doing that process of looking at it or storing it in an archive, that is still processing. And so really, again, whenever you've got any information that you've collected that's personal data about data subjects, then you are processing that information and you're captured by the GDPR. Now, I've mentioned before that it's all about data subjects. And data subjects are just defined, quite a short definition: identified or identified living individual to whom personal data relates. Quite straightforward. Or is it? Well, so what the definition of data subject means is that for research purposes, this is anyone who's identifiable from data which you hold, irrespective of whether the individuals have participated in research or not. So anyone you've got their data, it's personal data of a data subject. It can also mean any employees who will also be data subjects under the Act, as you will hold identifiable personal data about them. So for those of you that maybe work in organisations that offer recruitment services, or you're part of a field team or field service agency, but you've got data about your staff, your employees, then that information that you hold will also be personal data. One of the things that is one of the things that need to also be cognizant of is that if you hold information about businesses that are sole traders or unincorporated companies, and also potentially partnerships as well, depending on what the legal structure of the partnerships are, you also have to treat that data as personal data about data subjects as well. So it's not necessarily as straightforward as it might seem. And so again, if you do a lot of research, for example, with small businesses, and you think, oh, well, that's okay, all of those small businesses, that's B2B data, and it's not personal data in the same way. That's not necessarily the case. And so again, you need to be thinking about how you treat those kind of business records as well. So In terms of how the legislation is structured and who has which responsibilities, there are two primary definitions: data controller or controller. Both terms are used intermittently. And that is a person, a public authority, agency, or other body which alone or jointly with others determines the purpose and means of processing personal data. So what does that mean? Well, you are a controller if you keep or collect any identifiable data on participants, including, but not exclusively, names, email addresses, telephone numbers, and you determine the purposes for which and the manner in which personal data is going to be processed. So if you are a recruiter and you collect data of individuals who you might contact in the future for research recruitment, you are a data controller because you are determining the purposes for which and the manner in which that personal data is going to be used and processed. If you're an employee working and acting on behalf of your employer, your employer would be the data controller. And the Data Protection Act 2018 requires data controllers, which includes research recruiters, to register. Sometimes the process is called notify with the Information Commission's Office, the regulator. Okay, so you have to do this. It's an annual process. It doesn't cost very much. It's about £40. But you must do this process where you, in effect, say, I collect data. I'm doing it for these purposes. And for these type of individuals, and it's like an annual declaration that you must do. And the recruiters are not exempt from registration. So if you're an independent recruiter, you have a responsibility to notify with the ICO. It's a legal responsibility. You can't go through the notification of anyone else or anyone you're working for, whether it be a client or an agency. That's not the way that GDPR works. So you do have to take personal responsibility for that notification process. There is the other sort of class of people and organizations that do processing is the data processor or the processor. Again, the terms are used intermittently. That's a person, a public authority, agency, or other body which processes personal data on behalf of the controller. So that's the most important thing, is you're working under the instruction of somebody. So and that can be the case in terms of if you are working where you're being told what to do. You may be being given data and said, right, we want you to recruit from this data, and to find out the individuals that were prepared to take part in a project, for example, and you're literally, everything you're doing is under instruction from somebody else, then you would be a processor in that scenario. That doesn't, though, stop you being a controller for other things you do. You can be both a processor and a controller at the same time. And as I say, you will always be a controller for your business purposes, but there potentially could be projects where you'll be acting as a processor. So a processor could be a separate organization or person. It can be, you can have a number of processors working on the project at any given time. Again, that doesn't matter. There can be multiple processors. But processors have some direct legal obligations, but these are more limited than the controllers. But you would be a processor, as I said, if you're recruiting from a client database. And the GDPR places specific obligations on both controllers and processors. And it's really about degree of responsibility that is kind of the way the burden works in terms of GDPR. So if you're a processor and you're working on behalf of a controller, the controller is likely to, if something were to go wrong, the controller would have to take the majority of the responsibility for it. But some of the responsibility would be passed down to the processor if the processor is the one that has where things have gone wrong. The controller would have to take some responsibility for that because they picked the processors to work on their behalf, but the processor would also have responsibility and liability should anything go wrong under GDPR. So it's much more shared. This wasn't the case under the old Data Protection Directive and the old Data Protection Act, where everything was the responsibility of the controller. that's not the case anymore. And so the responsibility goes down the supply chain to all parties that might be involved in when any breach occurs. There's also a sort of extra processing requirements that need to be followed when processing what's called special category data. Now, again, this is sometimes called sensitive data, and again, this was in the old legislation, but has been expanded for the Data Protection Act 2018 and GDPR. And the special categories of data are personal data about racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, also biometric data, so that's things like such as fingerprints and retina scans, that sort of thing, health data, and that could include things like information about allergies, could include dietary information. So it's not just about, if you like, someone's complete medical file. Data concerning a person's sex life, and also data concerning a person's sexual orientation. Now, if you think about what happens within a research project, quite often you will be collecting some, if not all, of this type of information, particularly if you do opinion polling, certainly political opinions. You might quite often, for social demographic purposes, be collecting things like ethnic data. You may also be collecting things like information about someone's health, and also things like sexual orientation and so on. So researchers collect special category data quite often. And the important thing really is that for the most part, when you're collecting this kind of information, it must be done with the informed consent of the participant. I will talk about informed consent a bit later. But in effect, you can't try to guess this information. You need to ask somebody and get a response back when you want to collect this kind of information. So it's really important that you don't try to infer things about somebody. I know quite often it can be tempting saying, well, I don't want to ask, are they all of these kind of questions, but actually you do need to ask them, particularly if you're collecting special category data, because if you are collecting it, you have to collect it with informed consent. So let's talk a little bit more about the data protection sort of concepts and principles. The GDPR sets out 7 key principles. And again, these are quite similar to what was in existence in the old legislation, although they have been expanded a little bit. So that data must be collected lawfully, fairly, and transparently. And this kind of comes back to what I was saying right at the beginning, what's this legislation all about? So, again, it's just being really, really clear with people about what it is you're going to do and why you're going to do it. And if you're being very clear and it's obvious about what you're going to be doing, then you'll be meeting that first principle. The second is about purpose limitation, and this is to do with the fact that what you can't do is collect data for one purpose and then use it for another purpose. So when you're collecting data, if you're collecting data and it is for the purposes of recruiting individuals for research projects, then that's your purpose. You can't then suddenly use this information to set up a dating agency. I know it's a bit extreme, but you know what I'm saying. So whatever you say to somebody as to why and what you're going to use the data for, then you have to stick with that, and you can't then use the data for something else. Also, the important thing as well is about data minimization. If you don't need data, don't collect it, quite frankly, because also you've got obligations about this data. And actually, that will be one of the things that I'll be talking about in the second of the GDPR sessions next week. But there are lots of data subject rights that exist under GDPR, and one of which is access to data that's being held or against an individual. Well, if you've got loads and loads of data, you're just creating a massive job for yourself, because you've got to supply all that if somebody makes a subject access request. So keep data to a minimum. If you need it for recruitment purposes, then clearly you should keep it. But if you're not using it, get rid of it. One of the things that really frustrates me is I still sort of see people collecting data on people's fax numbers and things like that. When was the last time, genuinely, when was the last time any of us used a fax machine? even though that actually is, if you like, corporate data, it's data that's you're not going to use, you're never going to use, even in the business to business context. So again, why collect it? So think about the kind of data you collect. And I think we all slip into habits with our forms and our structure of the way that we collect things. We just collect it because that's what we've always done. But take a step back and think, why are we collecting this information? Are we going to use it? And if you're not going to use it, don't collect it anymore and get rid of the collected data you've got under that field of data if you're not going to use it. There is also a need for accuracy, and this data minimization and accuracy are very closely linked, because if you've also got to keep data accurate, it's a really another good reason for really keeping data to a minimum. Because again, if you've got lots and lots of data and it's got to be accurate and up to date, then you create a data cleansing task for yourself that could be really quite a big task. Whereas if you keep data to a minimum, hopefully that cleansing of your data will be much more of a straightforward process. Also, in terms of storage, so this is about data retention periods. You need to think about the data you've got, what you're using it for, and how long you realistically need it. And then for each of the different types of data that you hold, you set a retention period. So there might be certain things that you might want to keep for, say, the life of a project, something like maybe things like the consent forms that you might collect, or screener documentation, that sort of thing. But you might have it for the life of the project and maybe up to 6 months after the project, just in case there's any questions or something like that. Whereas there might be other records where you think, well, I'm where you've got multiple waves where you're going to be recontact people over a period of time. Well, then clearly you need to be keeping that data longer because you need to contact them again in the future. So again, it's thinking about what kind of things you're doing with the data, and what things you need to do in the future with it, and that will determine how long you need to keep it. And you need to set your policy. Just have a table saying this type of data I keep this long, length type of data this long, and so on. It is also very important to keep the integrity and the confidentiality of data. So this is data security. It's probably the thing that takes up the most time, because of course it's technology is changing all the time. You get patches coming out all the time. You get updates for your systems all of the time, and also thinking about your manual records. So also about putting things away, locking them away, and so on. But it's also really important to know that actually, if data is accidentally deleted, that's also a breach of this principle, because it's about the integrity as well as the confidentiality of the data. So actually making sure that your data isn't accessed and deleted or manipulated in any way, as well as just being accessed, is an important part of this principle. And the final principle is accountability. And so this kind of comes back to, again, this fundamental thing that I talked about at the beginning about what the Data Protection Act is about. It's about being fair and accountable. And this accountability is about, I'm afraid, this is about documentation. This is about your policies. This is about how you structure your work, how you do your work. And so that if you're asked the question or something goes wrong, you can go back to your record and say, right, I know what's happened here. I can show what I did, how I did it, why I did it in the way I did it. And if you've got those kind of records, if something does go wrong, you are in a much, much better position than if you haven't got the sort of appropriate documentation and policies in place. And so if we taking a step back and thinking about what you do, really the core concepts come down to transparency and accountability. Transparency is being transparent about what is happening in any process. That is the higher threshold of consent is important to this, and I'll talk about that in a minute. Effective communication and being clear, plain English, please, plain English. It doesn't need to be legalese. And in fact, actually, it doesn't help people, because that doesn't help them understand what's going on. Establish procedures for enabling rights to be exercised. And again, the second webinar in the series will talk the second of the GDPR sessions will talk more about that. And respecting for participants. Respect those participants. I always sort of say, respect the participants in the way, treat the participants in the way that you would want to be treated. And then hopefully that means you're establishing a good relationship with the participant. And for accountability, it's being able to demonstrate you've taken responsibility for all data protection measurements. And accountability applies irrespective of your size, although obviously how you implement the scale that you'll have to implement them to will obviously differ. But fundamentally, we're all following the same approach, whether we're a massive organization or whether you're a sole trader or a freelancer. The accountability, it is a risk-based piece of legislation. So it's all about what is the likelihood that something can happen and what kind of measures you can take to mitigate those kind of risks. It's a demonstrable compliance, so showing that you've gone through that thought process about risk and mitigation. Detailed written internal records, that is the big change between the old piece of legislation and this one. There's a lot more need for detailed written internal records. There's a need for mandatory breach notification, which I'll also talk about in the second webinar, and potentially the need to have data protection officers. And this really depends on the size and scale and the type of processing you do as an organization. Not all organizations need data protection officers, but certain types of organizations will. Okay, so that's the core concepts. We've talked about the overview, we've talked about the principles and the definitions and the concepts. Now let's talk about a little bit about the grounds for processing data. So within the legislation, there are a number of grounds available for processing of data. And in fact, there's more than the three that I'm going to talk about today. But the three that I'm going to focus on today are the three that are, for the most part, the ones that you would use, particularly for research recruitment. Now, there is legitimate interest, and the reason why I'm pausing a bit is that I personally don't think legitimate interest has much relevance within research recruitment, but I will mention it because it is one of those things that is good for you to understand what it is and how it works. So legitimate interest can be used if a data subject, so participants in our case, have a reasonable expectation that their data will be collected in the way that you're going to collect it, and in doing so, it doesn't harm the rights of the data subject, and those rights are being respected. I think this is less likely in for research recruitment because really, when would it be a reasonable expectation of a data subject that their data might be processed to be recruited for research purposes? I mean, it's not a reasonable expectation of most members of the public. But it could be for other types of research processing, depending on the sort of the type of data and the context in which it's collected. So as I say, I'm showing it to you to be aware of it, but it's really not the one that's most likely. There is also research exemption and public interest, which is within the legislation. And this is particularly the case if you do lots of social research projects, so which are in the public interest for a public task. And there are some exemptions and special conditions when you are processing data for this sort of thing. That's really quite specific and technical. And I would say that if you're doing this kind of project and using this grounds of processing, that you have a look at the MRS and SRA guidance, data protection guidance, because that talks much more about the terms and conditions you need to follow when doing this kind of public interest processing. And similarly, you can contact the Code Line service, and we can talk you through the things that you need to think about. But it can apply, and it could certainly apply if you do a social research project. But the one legal ground for processing, which by far and away is the most applicable for research recruitment, is consent. And consent must be freely given. It must be specific, informed, and unambiguous. And this is achieved by providing a clear statement or affirmative action signifying agreement to personal data being processed. So what does that mean? So there are some important characteristics regarding informed consent. Consent is not forever, and it can be withdrawn at any time. That's the first thing. Consent will not be valid unless separate consents are obtained for different processing activities. So what you can't do is, if you like, have a big statement that says, well, we might use it for this purpose, this purpose, this purpose, and we're collecting this, this, and this. Tick here to say you agree. Because what was the participant agreeing to? because actually the reality is quite often is participants might be and data subjects might be happy about certain types of processing for certain types of purposes, but not for other types. So what you need is single sentence statements for all of the different consents that you might need, and you set them out in that way so that it is clear, unambiguous about what the data subject or the participant is agreeing to. What you also can't do is what are sometimes called omnibus consents or forced consents, which is pre-tick boxes, definitely not, or assuming inactivity or non-response implies consent. So you can't sort of say, if I don't hear from you in a week, I'll assume that you're happy with this. You can't do that with informed consent. And as I've mentioned earlier, explicit consent is required for the collection of sensitive special category data. So if you're collecting special category data, you need to do it with consent. You can't try to use one of the other purposes for that. And so from a recruitment perspective, when do you need to be obtaining consent when you do data collection, when you're doing initial research, if you want to recontact somebody at any times, if you're going to be collecting recordings or you want to get use of photographs or anything else that you might be doing within a recruitment and ultimately the data collection exercise, you need to obtain consent for that. And individuals have the right to withdraw that consent and should be informed of the right to withdraw prior to giving their consent, so that they understand that in effect they're not sacrificing something which never can be sort of brought back. Written, electronic, and oral consent are all valid, but consent must always be verifiable to demonstrate that consent was legitimately obtained. Now, obviously, with written, that you might get someone's signature, and if, for example, when you're getting a consent form before a sort of a group environment or something like that, and similarly electronic, you might have a chain of communication which shows that somebody's consented to something, email or whatever. Oral consent obviously is more difficult, but what you can do is things like actually note down when you spoke to somebody, how you spoke to them, and on what date. So again, you're showing that there's a chain of no, I spoke to them on the phone on this date at this time, and so on. That could be verified if it needed to be, if there was a sort of somebody really questioning that they'd ever given verbal consent. But you need to, obviously, this comes back to robust record keeping again. So showing who consented, when they consented, what they were told, how they consented, whether they've withdrawn from the consent, and if so, when. And again, so when you're thinking about your project records and the way that you keep things and log things, you need to be thinking about the purpose of the recruitment, the location, time, and duration of the activity, the type of client, what was it for, what was the type of thing they consented to, the monitoring and observation and recording arrangements, incentives and how and when they will be paid, any other activity like pre-tasks or post-tasks, and also any recontact arrangements and on what the purposes would be for that recontact. All of that would need to be being logged. That is about being accountable and demonstrating, if you like, your sort of consent in terms of the data collection. But they're also, for informed consent to meet the GDPR requirements, you also need to supply certain information to be meeting the legal requirements regarding informed consent. So that would be the data controller's identity. Now, this could be multiple parties. It could be the recruiter, the research agency, it could be a field agency, could be the client, could be a combination of all of them. And the details of those controller or controllers, you would need to be able to provide those as well, because again, one of the requirements of the legislation is data controllers must be identified when data is being collected, and there must be information so that the data subject can contact the data controller if they need to. The purpose of each processing activity, so that consent is being sought for, so that comes back again. If you think about it at the beginning when we were talking about the principles of data protection, this is about the purpose, type of data being collected, and if special category data will be collected. And also, I would say here as well, if you're ever going to be collecting sensitive data that might not be legally classified as special category data, but could have sensitivities around it, then you should be also flagging that kind of data is going to be collected. the existence of the right to withdraw, information about the use of the data for decisions, if it's going to be used for things like automated processing. Again, this could be depending on the nature of the job that you're doing and the client that you're working for, and the end client you're working for. It's possible the information might be used for automated processing, so you need to know that if it's going to be. And of course, this, with more and more AI and machine learning processes coming in by end clients as well agencies, this is going to become an increasing factor. And also possible risks of data transfers to third countries. So again, if there is a likelihood or a possibility that data is going to be transferred to a third country, even if it's not by you, but might be by another organization up the supply chain, if you're collecting the data, you need to be telling participants that data transfers is potentially going to be happening. Okay. So we've talked a bit about client-supplied data, and I thought it would be good just to reflect on some of the requirements for client-supplied data, because it's an area where there are things that if it goes wrong, the consequences can be quite significant. So when you receive client-supplied samples for use in recruitment, individuals must be told during data collection the source of their data, and this can be revealed at the end of the session if participants agree to participate on this basis. So you don't have to reveal it up front if you're worried about bias and all those kind of things, but you reveal it at the end. Confirm with clients that they have checked the samples and that the personal data can be used for research purposes. So if you're going to be given data that you're going to be used for recruitment, absolutely you need to make sure that and get confirmation that it is data that you can legitimately use. I mean, if you use it and it can't be used for research purposes, that isn't your fault. That is a problem with the client who supplied the data. But equally, it is always worth asking the question. Confirm the method with clients the method of contact that's allowed for client-supplied samples. So again, this is partly to do with good project management as well, as much as anything. But is it telephone? Is it going to be by email? Is it going to be by social media? What is it? How is it going to be? So to make sure that they're happy with it, with the form of contact. Report back immediately if any complaints or data subject requests are received during your recruitment activities. So if somebody says you've contacted them on behalf of a client, and this person says, "I do not want them to contact me," you need to be feeding back that data request immediately back to the clients, because that is a data subject right, and that right needs to be enacted. So again, I will talk more about this in the second webinar. And as client side data controllers, they have a responsibility for filling any data subject requests relating to data subject rights, which is the reason why passing back the information when it relates to a GDPR right is so important with client supplied samples. The thing is, of course, is we're not there, and researchers aren't, and recruiters aren't there to basically update a client's database records, unless that's the nature of the exercise that's being undertaken. Obviously, if that is what the purpose of a project is, then clearly that's what it is. But for the most part, if you're doing research recruitment, it's to recruit people to take part in groups or depth or whatever else it might be. It's not, you're not there to sort of to be literally getting new address details and all this sort of thing. But what you can do is flag that a record is wrong in terms of, if for example, in the course of doing recruitment, you found out that basically someone has moved house, and you can flag a record to say they're no longer at this address, but it's not your job to provide the details of that new address. And as much as anything, it's because clients will have, there are quite strict protocols to follow to make sure that they get the correct address of people, and that they're not, their customer records aren't being manipulated in some way or hacked or whatever. So they'll have very detailed screening protocols that would need to be followed. So even if the information would be to collect and shared back, they can't use it anyway because they'd have to go through their processes. Don't do it. You don't need to do it. It's the client responsibility to do that sort of thing, unless the nature of what the project that you're actually doing is to update the client database. And also, sometimes in the course of doing recruitment and contacting participants, you might be told something about particular dissatisfaction. This particularly happens, for example, if you're doing customer satisfaction work. where somebody said, yeah, I bought this new washing machine, it doesn't work, or something, whatever it might be. Those kind of things. Those kind of specific complaints can be fed back, not with any confidential research data that's been attached to it, but if there's a specific thing that the client needs to sort out, which is to literally fix something, then obviously that information can be passed back. But before you do that, you need to get the consent of the participant that the information is going to be passed back for that purpose, to get their complaint resolved before you do it. And it's advisable that you basically keep a sort of standard list of annotations that you use on your recruitment databases and your lists, so that you have a standard set of classifications, or however you decide to do it. This address declined to be interviewed. Didn't meet the criteria, no phone, no answer, whatever you want to use, that you're using a sort of standard set of annotations so that you know which ones you can be passing back to clients and which ones you cannot. And that is really important also, is in terms of what you can and can't pass back to clients. Quite often, your client will sort of say, well, what we want to know is, who met the criteria and who didn't meet the criteria. What you can pass back is the numbers. So 10 were not at this address, 9 declined to be interviewed, 8 didn't fit the criteria. But what you can't do is give the individual names of those individuals unless the participants have explicitly consented to have the information passed back for that purpose. And for the most part, in a research project and recruitment, probably they won't have been. But also the other thing as well is really, really important to remember is you, as a recruiter, you cannot retain any client supplied data for your own use as a recruiter. You can't take customer databases and customer names and add it to your own database for future recruitment, because the clients won't be giving you the data for that purpose. If you establish contact with participants and participants say, I'd really like to take part in some more research actually in the future, I've really enjoyed it, or whatever, then you establish a separate relationship with that individual that is outside of that of the client data, but you can't be taking client data. And that is my final slide. Now, I do have time for any questions. If you do have any questions, please put them through the Q&A function. There might not have been any questions, or there may be questions that you have regarding some of the topics that I'm covering in the next session. Just to remind you, the topics that I'm going to be covering are participant rights. So I will be talking much more about things like subject access rights, the right of deletion, alteration, and also things like data porting, all of those kind of things. I will be covering all of those next time. Also about what to do when things go wrong, and the stages you need to go through, and the process you need to go through, and the time frame that you need to follow it, will be the topic of the webinar, which is basically the same time next week. And similarly, if you have watched this webinar and have found it useful, the recording of this webinar will be available. It will probably be in about a week's or so time, and it will be on the recruiter, the recruiter accreditation scheme page on the MRS website. The recording from the webinar last week is already up, which was on social media and emerging techniques. So if you missed that one, you can access that one. That's already up. But this one, as I say, will join it in about a week's or so's time. I've got one question so far. What is judged to be explicit consent, i.e. for special category data? Basically, that's informed consent. So explicit consent, informed consent, sort of same thing really, but really in the research context, you ask a question and you get an answer. And the question will be, is it okay? Can we use your data for all these purposes? And you get the answer yes to that. That's then you've got the consent. But remember, the information you have to relay in order to be informed consent. But if you're standing in front of somebody, you ask a question, you get an answer, then that will be the consent, and then you note down that consent or you get them to sign something or whatever, and then you're meeting the informed consent requirements. So, and that's, to be honest, the recruitment process lends itself to informed consent, explicit consent, because it's all about approaching people and asking them, certain questions and screener questions and all these kinds of things to see whether they meet a project. So as a process, it naturally lends itself to meeting informed consent. You just need to make sure that the legal requirements, as defined within the legislation, are being met when you do so. Well, that is the only question that I have received. And so I'm going to draw the webinar to a close now. I want to thank you all for your time today. And I hope you found the webinar useful. And I hope that you will join me for next week's webinar at the same time, same place. Oh, and somebody just come through. Would the collection of social media public handles to contact review suitability be legitimate interest? Would the collection of social media public handles to contact review suitability? Potentially, yes. Although you would, if you were using social media handles as a way of potentially identifying people that you then would target, it's kind of, you would be, the legitimate consent would be the first bit, and then you'd get into informed consent as you make direct contact. So you kind of go from legitimate interest to informed consent through the process of actually contacting individuals to then see if they want to take part. And that's also the important part. The grounds for processing can change from one thing to another, depending on where you are in the process. That really is going to be my last question, I think. I've had a thank you, Deborah, which is very nice. I hope you've all found it an interesting webinar for today, and I will see you hopefully next week. Thanks very much. Bye now.